Hello. Last week on the Gracie Gato podcast, we ended on a question. We had spent 25 minutes in the city of Concord. We had walked through 10 years of identical $12,500 checks. We had read the 2008 resolution that said nonprofits pay for police labor on a fee basis. And we had read the city's own 9-month status report admitting they hadn't. We had pulled the campaign finance receipts from a 2017 city council race that attracted statewide political money for no obvious reason. And we ended on the name of the city councilor at the center of it, Amanda Grady Sexton, chair of the Concord City Council's Public Safety Committee. And I told you last week that Councilor Sexton has a day job, and that day job puts her at the very center of the legislative lobbying and legal infrastructure that everything we just talked about depends on. So tonight, I'm going to tell you what that day job is, and then I'm going to tell you about a lawyer wearing 5 different hats like an old vaudeville movie, representing 5 different sets of clients on 5 different sides of the same set of cases simultaneously. Welcome to the Gracie Gato podcast. Pour yourself something neat. Whatever you've got that asks you to slow down, because this one we have to take slowly. Start where we left off. Amanda Grady Sexton by Monday evening, when this Concord City Council meets, she is the chair of the Public Safety Committee, the body that oversees the Concord Police Department, the same department that, as we established last week, provides uncompensated services to a domestic violence nonprofit chaired at the time by then mayor's wife. That nonprofit falls under the umbrella of Amanda Grady Sexton's employer, the NHCADSV. So by day, every other day of the week, since at least 2010, she has been Director of Government Relations, and then Director of Public Policy, and lately the Director of Public Affairs for the New Hampshire Coalition Against Domestic and Sexual Violence. All the same job, just conveniently changing titles, and as scrutiny on the organization focuses on her, the NHCADSV. I want to spend a moment here because most listeners outside of New Hampshire, and frankly most listeners inside of New Hampshire, don't know what the NHCADSV does. So, we're called the Coalition. It is a statewide coalition of local domestic violence and sexual assault nonprofits. Thrive. The Concord shelter at the center of last week's episode is a member program, and so is WISE in Lebanon. So is Bridges in Nashua, so are about a dozen others. So the coalition does 3 main things. 1, it serves as the pass-through for Federal Violence Against Women's Act funding, VAWA money, and Federal Victims of Crime Act funding, VOCA, to its member programs. So tens of millions of dollars a year statewide flowing from the federal government through the coalition out to the local crisis centers. This is federal grant money is released to the coalition via the Executive Council, who typically receives requests for it from the Attorney General's office. 2, it trains New Hampshire police departments and prosecutors in what it calls best practices for sexual assault investigations. By its own public statements, this training shapes the pre-trial narrative in cases statewide. Officers respond differently, prosecutors change differently, sane nurses document differently, because the coalition got there first to train them all. And three, the coalition lobbies the New Hampshire legislature on domestic violence and sexual assault policy. It opposes or supports bills, it mobilizes its member programs, it coordinates testimony, it brings in members of the AG's office, police department's prosecutor's office to testify for bills it wants passed and against bills it wants killed. And the Director of Public Affairs, the person in charge of that lobbying operation, is the sitting chair of the Concord City Council Public Safety Committee, a member of the Rules Committee, a member of the Fiscal Spending Policy Committee, and a member of the Manager's Review Committee. Now, I want to acknowledge, before we go any further, that none of this is secret. You can look up Amanda Grady Sexton on the NHCADSV's website. You can look her up on the City of Concord's council page. The dual role is right there in your face, mocking you. But it's also not in any meaningful sense disclosed. It's not disclosed in criminal trials attended by Councilor Grady Sexton either. She doesn't wear her lobby badge in those trials. Jurors, defendants are not made aware of what her role is. Her organization edits juror questionnaires, writes victim impact statements, and trains and coordinates state witnesses as well. When the Concord City Council voted on the annual $12,500 appropriation to Thrive, a member program of the coalition where Sexton works her day job, is she recused? I have not been able to find any record of her recusal at all. When the Public Safety Committee, which Sexton chairs, took up matters relating to Concord PD's uncompensated relationship with Thrive, is she recused? I have not been able to find any record of recusal. When she ran for re-election in 2017 and a partner at the law firm representing the coalition donated $300 to her campaign, did she disclose that? The donation came from her employer's general counsel? I have not been able to find any record of disclosure. The dual role is visible. It is not just acknowledged. Friends, the rest of this episode is going to be about one man. I want to introduce him properly because he is, by my count, the single most consequential private attorney operating in New Hampshire today. And most New Hampshire residents have never heard his name. His name is David A. Vicinanzo. Bar number 9403, partner at Nixon Peabody, LLP, the international law firm, practice group, government investigations, and white-collar defense. So let me list that for the record. The hats he wears. So hat number one, he is the counsel to the New Hampshire Coalition Against Domestic and Sexual Violence, the same coalition where Amanda Grady Sexton works her day job. Hat number two, he has represented simultaneously and has recently, as 2018, a group of faculty and administrators at St. Paul's School in Concord, who were the targets of a New Hampshire Attorney General's grand jury investigation into child endangerment. And we'll get to that in grand jury in a minute. Hat number three, here is, as of 2024, the lead trial attorney for a group of plaintiffs suing the state of New Hampshire over decades of abuse at the Youth Development Center, the YDC. The Meehan verdict, $38 million. Front page coverage. He's the lawyer in that photograph. Hat number four. He was appointed in December of 2021 by the New Hampshire Supreme Court, a court whose Chief Justice, Gordon McDonald, is his former law partner at Nixon Peabody, to serve as a member of the court's task force on domestic violence in the New Hampshire Judicial Branch. Hat number five. It's getting ridiculous. Per the reporting of multiple sources, he has served on the governor's task force on related matters without filing the financial disclosures that membership on such a task force ordinarily requires. Hat number six. He represents the Diocese of Manchester Catholic Charities, which is the master organization of dozens of schools, hospitals, nurses, homes, clinics. According to RSA 169C3, 7, child placing agency means that the Department of Catholic Charities of New Hampshire, or Child or Family Services of New Hampshire, or any successor organization. So that's 6 hats. 6 hats of clients, 6 hats of interest. Some of those interests align with each other. Some of them, by honest measure, scream conflict. The clients who lobbied for the grand jury investigation, the NHCADSV, were the same coalition whose member programs received funding from that settlement that ended it. The faculty and staff whose identities Vicinanzo's filings protected from public disclosure were employees of the same school whose alumni, and in the YDC cases, the state that licensed similar institutions. Vicinanzo now represents on the other side of that table. This is not a hypothetical conflict. It is an actual conflict. And we know it is an actual conflict because the Deputy Attorney General of New Hampshire told Mr. Vicinanzo so in writing on at least 2 separate occasions. And the position Mr. Vicinanzo took in response was to keep going anyway. Now, the 2 warnings I'm about to read you came out through a right-to-know request, New Hampshire's version of the Federal Freedom of Information Act. The documents are stamped with RTK numbering, which means they have a chain of custody. They are real, they are public, and they are quotable. The first email I want to read to you is dated February 2nd, 2018. 8:01 in the morning from David Vicinanzo at Nixon Peabody to Jane Young, at the time the Associate Attorney General of New Hampshire, Director of the Division of Public Protection, now the United States Attorney for the District of New Hampshire. The subject line is SPS employees. I'll read to you now. Hi, Jay. I've been asked to serve as pool counsel for numerous SPS employees to speed the process most efficiently. Can we talk today to set up a possible staggered schedule for interviews over the couple of weeks? I reached Jim Rosenberg last night, and he may have spoken to you. I'll be in Boston today, but I'll be on my cell. Hello. Thanks, Dave. That's the opener. Mr. Vicinanzo is telling the Deputy AG that he is now representing, quote, numerous SPS employees, the targets of the grand jury investigation she is currently running. Same day, 12:46 in the morning, 4 hours and 45 minutes later, Jane Young replies, Dave, we can discuss, but our position remains the same on the conflict issue and the need for testimony before the grand jury next week. As I noted, I will be out of the office, but Jeff will be here for the remainder of the day. Jane, our position remains the same on the conflict issue. Read that sentence with me. Remains the same. You only use the words remains the same when you have already said something before and you are just reiterating it. Which means there is somewhere in the New Hampshire Department of Justice's correspondence files an earlier email, earlier than February 2nd, 2018, in which Jane Young first told David Vicinanzo that he had a conflict of interest. The February 2nd email is the second warning, at least. If anyone listening to this podcast has filed a right-to-know request for the first warning, please get in touch with me. I'm still looking for it. The Department of Justice's RTK production for the SPS investigation runs into the thousands of pages. The earlier warning is almost certainly there. But here's what happened next. And this is the part that when I first read it, I had to put my laptop down. Mr. Vicinanzo did not withdraw. He kept representing the SPS employees. He scheduled their grand jury appearances. He negotiated their testimony. And over the following 10 months, the New Hampshire Department of Justice, Jane Young's department, continued to do business with him. Now, I have in front of me the email chain from March 4th, 2018. Young confirms a witness scheduling decision to Vicinanzo. September 4th, 2018, Young schedules another witness interview. December 16th, 2018, Young commits to sending Vicinanzo a copy of a prior court order on grand jury disclosure. December 19th, 2018, Vicinanzo asks her clarifying questions about her own motion. The conflict is on record. The whole continued anyway, or the work continued anyway. This is not how conflicts are supposed to be handled. The textbook response when an attorney is told they have a conflict is one of three things. They withdraw, the prosecutor moves to disqualify them, or the court rules on the conflict on record. None of these things happened. So what happened instead was that the grand jury investigation continued. The SPS employees continued to be represented by Vicinanzo. The New Hampshire AG's office continued to schedule with him. And 10 months later, in December 2018, Mr. Vicinanzo filed a sealed motion that ended the entire investigation in his client's favor. Let's talk about the filing. December 28, 2018, Friday afternoon, 3:19 p.m. A motion is filed in Merrimack County Superior Court, filed under seal, submitted by attorneys David Vicinanzo, bar number 9403, and Kirsten Schultz, bar number 20682, both of Nixon Peabody. The caption identifies their clients as Ann Doe 1, 2, 3, and 4, and Arthur Doe 1 and 2. 6 witnesses to the St. Paul School grand jury investigation, each filing pseudo-anonymously, each represented by Mr. Vicinanzo. The motion itself argues, and I am summarizing because it remains under seal, that these 6 witnesses object to the public disclosure of the grand jury report that the Attorney General's office has been preparing. The same day, 3:27 p.m., 8 minutes later, Jane Young responds, "Thank you, Dave. Have a happy new year." Jane, have a happy new year. So the Deputy Attorney General of the state of New Hampshire, having just been served with a motion that would, over the next 9 months, result in the permanent sealing of her own grand jury report, wishes Happy New Year to the lawyer who filed it. 8 minutes after the filing, I want to be very clear about what I am and I am not saying here, okay? I am not saying Jane Young was corrupt. I'm not saying she was bought. I am not saying anything about her motives. Jane Young is a serious lawyer with a serious career who became the United States Attorney for the District of New Hampshire. The President of the United States nominated her. The Senate confirmed her. She then went on to represent the New Hampshire Supreme Court Justice Gordon MacDonald, and threatened to go around AG John Formella to Governor Kelly Ayotte on his behalf. What I'm saying is that the culture of the New Hampshire Department of Justice, as evidenced by the email exchange, treats the New Hampshire defense bar, even a defense bar that the department itself has flagged for conflicts of interest, with a level of collegial intimacy that produces email correspondence reading like a country club Christmas card list. And that culture has consequences. The consequence in this case is that the grand jury report at the center of this investigation was sealed. 2019, Merrimack County Superior Court Judge Richard McNamara, after 9 months of motions, replies, hearings, and the kind of procedural maneuvering that makes journalists drink, Judge McNamara rules. The St. Paul School grand jury report will not be made public. The ruling is technical. It is grounded in a careful reading of New Hampshire's grand jury secrecy statutes. It cites precedents. It applies legal standards in a way that a court, if anyone had appealed, would likely have affirmed. But the outcome, regardless of the legal reasoning, is this: a grand jury investigation that took 2 years, that involved the testimony of dozens of witnesses, that was lobbied for by the NHCADSV that was conducted by Concord PD with the support of the AG's office that resulted in a settlement agreement naming the coalition and its local member program as beneficiaries, produced a final report that nobody outside the parties has ever read to this day. It is in a filing cabinet somewhere in Merrimack County Superior Court under seal permanently. Mr. Vicinanzo praised the ruling in a public statement. He did not mention that the Deputy Attorney General had, by that point, told him at least twice in writing that he had a conflict of interest. Nobody in the press asked him about it until tonight. Now, friends, I want to close this episode by walking you through what I have come to call the family tree, because once you see it, you can't unsee it. It's like a bad Three Stooges movie. You know, it's a family tree of relationships, not blood, but professional. But in New Hampshire's legal community, the line between the two is blurrier than most states care to admit. Now, let me start at the top. At the top of the tree is the New Hampshire Supreme Court. The Chief Justice is Gordon MacDonald. Before he was Chief Justice, he was the Attorney General of New Hampshire, the Attorney General who oversaw the St. Paul's grand jury investigation. Before he was Attorney General, Gordon MacDonald was a partner at Nixon Peabody, where David Vicinanzo is currently a partner. In December of 2021, Governor Sununu issued an order creating a task force on domestic violence in the judicial branch. The court declined to specify which justices voted to issue the order and appointed as a member of the task force David Vicinanzo, Chief Justice Gordon MacDonald's former law partner. One step down the tree is the United States Attorney for the District of New Hampshire. That position was held until January 2025 by Jane Young. She hired David Vicinanzo's son, Matthew Vicinanzo, to be federal prosecutor under her. And she hired Jeff Ward, the Jeff she referred to in the email to Vicinanzo, also to a federal prosecutor after he deleted the files of 28 or more police officers on the Lori list, the list of corrupt police officers. Before she was the U.S. Attorney, she was the Deputy Attorney General of New Hampshire, the prosecutor who told David Vicinanzo twice in writing that he had a conflict of interest in the SPES matter, and that continued to do business with him hiring his son. So Mr. Vicinanzo's son is currently an assistant United States attorney serving under Jane Young. So I want to flag that again.
I'm Gracie Gato. This was the Gracie Gato podcast. Please stay curious and be agents of chaos. I'll see you on the other side.